Now, earlier this week, the Constitutional Court ruled that a section of the South African Citizenship Act of 1995 pertaining to dual citizenship is unconstitutional. The disputed provision caused South African citizens to lose their citizenship automatically if they voluntarily acquire citizenship in another country, unless, of course, they have prior permission from the Minister of Home Affairs and received a retention of citizenship letter beforehand. Now, the legal challenge was filed by the Democratic Alliance against the Department of Home Affairs in a matter that has taken 10 years to conclude. But to talk more about what this means for millions of South Africans who involuntarily lost their dual citizenship, we're joined by Craig Smith, immigration lawyer at Craig Smith and Associates. Craig, thanks for joining us. It's good to have you on the program.
Good morning, Leanne. Thanks for having me.
So, I mean, this has been going on for 10 years, and a lot of people have been impacted in the meantime. So perhaps maybe talk to us about, how this has worked and what this ruling actually means now.
Sure. Well, actually, this has been going on since 1949, when the first Citizenship Act was passed. So we go back a long time. This is not just 1995. In fact, the 1995 Citizenship Act has literally mirrored the provision from 1949 in that Citizenship Act. So it has been going on for a long time. The issue really in this case is the rights of South Africans not to be deprived of their constitutional right and protection to citizenship under Section 20. So in this matter, Section 20 was essentially put up, that right to protection not to be deprived of citizenship was put up against that provision under the South African Citizenship Act, which says that if you seek to take on another nationality whilst being a South African citizen, and you take and voluntarily take up another nationality, you are expected to get in touch with the department and submit an application within the department to the minister for the right to then take on that second citizenship. And that was the nub of the case, and it centered around Section 20 of the Constitution.
So, I mean, if we look back now at the legal implications of this ruling for South Africans who have lost their citizenship through since 1995, what does this mean now? What will happen?
Well, there is a provision, and in fact, in the judgment, it was made clear that those who have been affected will be deemed not to have lost their citizenship from the 6th of October 1995, when that Citizenship Act was promulgated, meaning it came into effect. So effectively, the remedy they now have is under it was contained in that judgment, and it's found in Section 15 of the Citizenship Act, where the minister now must issue a certificate of citizenship. So there is that remedy contained in the Act itself, which is good, but I guess it's for the minister and his task team to set up the mechanism in which they can now actually avail themselves of that provision of Section 15.
I imagine that this is going to also result in a lot of people coming back and pleading their cases to reinstate citizenship. Thousands, maybe hundreds of thousands. Do we know how many people have actually lost their citizenship through this and now are eligible to reclaim it?
Well, let's just make it clear. They shouldn't have to plead their case. Effectively, the Constitutional Court has confirmed the constitutional invalidity of that Section 61A of the automatic loss. So you have every right to seek that reinstatement of your citizenship, because remember, the decision said you are now deemed to have been a citizen with the effect from the 6th of October 1995. I can tell you, just in response to the other part of your question, it is estimated that about 2 million people have left South Africa who may be affected. I mean, it's a guesstimate, but that's the sort of number that's been thrown around. I've had first-hand experience of many of my clients who wish to return to South Africa. And what has happened is the parents leave South Africa as South Africans, start a family, without realizing it, then become eligible for naturalization of another citizenship, wherever they are in the world. And then they didn't realize that they had this obligation to seek permission of the minister, and without doing so, they immediately and automatically, without knowing, lost their South African citizenship. And then when they had children, those children then lost the right to South African citizenship. Sure. And it could now be, because it's so long, it could be those children's children. So so not only did the parents lose their citizenship, but then it would have meant that the children in turn would also lose their citizenship. So that's the problem that we have, and that's how it affects families.
And Craig, let's just say that the parents leave, they have children, and then their children have children. Are they all eligible to get that citizenship back?
Absolutely, because it will all emanate from the parents.
Okay.
So when the parents left the country and they took up another nationality without realizing it, they would have lost their citizenship. Yeah. So, for example, you can get citizen by descent, where the children are born abroad to South African parents. But because the South African parents lost their citizenship, they are effectively become foreigners. That's the sad part. So the kids can't get citizenship because the parents don't have citizenship, and that's the knock-on effect.
So, I mean, I suppose you've answered the question, but it was what rights were actually being violated under this old provision?
Well, the section, the key section, the provision is section 61A, which said, well, you must contact us before you take up a second passport. The court said, well, it's actually irrational. And it makes no difference whether you do a retention or you don't do a retention. The fact of the matter is that the people are in the same position, and the court effectively said it's irrational to have to approach the minister to seek permission, where those who do get the dual nationality and those who don't should not forfeit their nationality. So they argued that it's just completely irrational. Home Affairs took the position that they said, well, you have the provision under section 6.2 where you have the right to ask the minister for permission, but the court said, well, this is unconstitutional vis-a-vis section 20 of the Constitution, which says South Africans can't be deprived of their citizenship.
Right. So now it starts, as you say. I know that it shouldn't be a big process, but it is. At the end of the day, everything is a process now. Yeah. Practically speaking, what steps should affected individuals take now? And I mean, how long could this process actually take for them?
I think that's a very difficult question. I think it's for the minister who, by all accounts, we have a new minister who seems to be on the ball. They've welcomed the decision, and I think it is a good decision. If you think about it, if one sets up the necessary team with the skills and the efficiencies and those operational abilities, it should not be such an onerous task. It depends how Home Affairs wants to take this. If Home Affairs sets out a whole set of cumbersome requirements, it's going to make it more onerous and more time-consuming. You're going to have to show you're a South African citizen by birth if you have a birth certificate. But those documents will all be there with those affected couples. So it should not be. It should be well thought through, and it should have the requisite people in the right position at the right time to be able to process this. But I would imagine the minister is mindful of this decision. At this stage, all those people are deemed to be South African citizens, and he has now the obligation to introduce a mechanism to allow those people to swiftly get the rights that they deserve, which will be their citizenship.
Yeah, indeed. And so I suppose now we wait for Home Affairs to publish guidelines, and we see what it is that people need to have to get their citizenship back. So this is still, I mean, it's obviously it's been ruled, but there's still a whole process that needs to be followed. And this is where we need to now hear from the Department of Home Affairs. And one can only hope, as you put it, that there isn't going to be too much of a rigorous process, that they have to, you know, all the hoops they have to jump through in order to do this.
Absolutely. Yeah. I mean, at the end of the day, you're deemed to be a South African citizen with effect from the date of the judgment 2 days ago. So the challenge would be, I mean, just think of it. You may get people thinking that they can now automatically come into South Africa as citizens. Can you imagine the Home Affairs officials at the ports of entries, at the airports, etc., probably not knowing what to do? Yeah. But similarly, those affected people would also not know what to do if the minister doesn't, get this in motion as soon as possible.
All right, let's leave it there. Thank you. Craig, a busy man, I imagine. You're speaking to a lot of people about this one because it's a big ruling, and as you said, affecting millions, perhaps 2 million people at least. Yeah, Craig Smith, immigration lawyer at Craig Smith & Associates, talking to us about the recent Constitutional Court judgment making way for South African citizens who voluntarily lost their dual citizenship after obtaining citizenship of another country to have their rights restored.